There are people who respond to injustice by going quiet, who absorb what has been done to them and fold it inward, and survive by making themselves small and still and waiting for something to change from the outside. And then there are people like Diane O'Yelleran. Diane was 43 years old when she was convicted of corporate fraud in a Melbourne, Australia courtroom in 2009. She was a financial journalist, 14 years of covering markets, corporate governance, and exactly the kind of white-collar crime she had now been convicted of committing. She had not committed it. She knew she had not committed it. And she knew, with the specific knowledge of someone who had spent 14 years investigating financial crime, how to find the evidence that would prove it. The problem was that she was in prison. The solution, the entirely characteristic solution, was to investigate from inside. Diane O'Yelleran spent 3 years in a Victorian women's prison filing Freedom of Information requests, corresponding with financial regulators, building a case file from her cell that her own attorneys had not been able to build from the outside. She used every legal avenue available to a prisoner, and several that required considerable creativity, to obtain documents that the prosecution had not disclosed and the defense had not found. She was released after 3 years when the evidence she had gathered, combined with new analysis by an independent forensic accountant, established conclusively that the fraud had been committed by her former colleague and not by her. This is the story of a journalist who would not stop working, and of what happens when the person best equipped to investigate a case is the person the case has imprisoned. Diane O'Yelleran had grown up in Melbourne, the daughter of a Nigerian father who had come to Australia in the 1970s to study engineering and had stayed, and an Australian mother who taught primary school. She had studied economics and journalism at the University of Melbourne and had been drawn to financial reporting because it sat at the intersection of numbers and human behavior, the place where the most interesting stories lived. She had worked for 14 years at a Melbourne financial publication, covering corporate governance, market regulation, and white-collar crime. She had broken 3 significant stories in her career: a fund management scandal in 2001, a superannuation fraud in 2005, and a market manipulation case in 2007 that had resulted in regulatory action against 2 major firms. She was known in financial circles as someone who read balance sheets the way other people read novels, for plot, for character, for the thing that was not supposed to be there. In 2007, she had begun investigating a Melbourne-based investment firm called Meridian Partners, no relation to the British construction company mentioned in an earlier episode, that had been showing unusual patterns in its client account movements. Her editor had assigned her to look into it. Her colleague on the investigation was a 38-year-old financial analyst named Stuart Greer, who worked adjacent to the newsroom as a data specialist and who had, over 18 months of collaboration, become indispensable to her understanding of the technical financial structures involved. What Diane did not know, what she would spend 3 years in prison discovering, was that Stuart Greer had been using their investigation to do something she had not anticipated. Stuart Greer had been, for the previous 2 years, engaged in a sophisticated scheme of his own. He had been using his access to financial data, including data provided to him by Diane as part of their investigation, to make targeted short-selling trades on the shares of companies that their investigation was about to expose. This is a form of market manipulation, using non-public information obtained through journalism to trade on financial markets is a serious regulatory offense. Stuart had made, over 18 months, approximately 400,000 Australian dollars from these trades. When the Australian Securities and Investments Commission began investigating the suspicious trading patterns in early 2008, Stuart Greer made a decision. He decided that the cleanest way to protect himself was to ensure that someone else was identified as the primary actor. And the person with the most obvious access to the same non-public information, and the most obvious motive as a financial journalist with financial pressures, was Diane O'Yelleran. He spent several weeks carefully creating a digital trail. He accessed systems using credentials that created ambiguity about whether the access was his or Diane's. He forwarded selected documents to an email account that could be attributed to Diane. He made one carefully positioned phone call that he ensured was logged in a way that implicated her. It was sophisticated work, not perfect, as Diane would eventually demonstrate, but sufficient for the initial investigation and prosecution. ASIC contacted Diane in April 2008. She cooperated fully. She provided everything she had. She said Stuart had been involved in all the relevant analysis. She said she did not understand how her credentials appeared in the logs they were describing. Stewart, interviewed separately, was cooperative, regretful, and pointed quietly but persistently at Diane. Diane was charged in August 2008. Stewart Greer was not charged. He was instead listed as a prosecution witness. The trial of Diane O'Yelleran opened in Melbourne in March 2009. It lasted 4 weeks. The prosecution's case rested on the digital trail Stewart had constructed: the access logs, the forwarded documents, the phone record, and Stewart Greer's testimony. Stewart was, as a witness, exactly what the prosecution needed: technically sophisticated, professionally credible, and carrying the specific authority of someone who had worked closely with the defendant and had reluctantly, sadly, concluded that she had done what she was accused of. The defense challenged the digital evidence. They brought in a computer forensics expert who raised questions about the ambiguity of the access logs and pointed out that the credentials could have been used by more than one person. The prosecution countered with their own expert, who testified that the pattern of access was more consistent with Diane's working habits than with anyone else's. Diane took the stand. She was precise, technical, and entirely herself, 14 years of financial reporting visible in the way she engaged with the technical evidence, comfortable with complexity, willing to explain and re-explain. She denied everything. She said Stewart had been the one with the trading knowledge and the trading opportunity. She said she had no financial account in the places the prosecution described. She said the digital evidence had been constructed. The prosecution suggested this was the response of a sophisticated person who had been careful, who had understood that evidence could be attributed to someone else, who had, in short, done exactly what they were accusing her of, but in the opposite direction. It is a very difficult accusation to defend against. The claim that your evidence of innocence is itself evidence of guilt. The jury deliberated for 7 days. They found Diane O'Yelleran guilty on 3 counts of market manipulation and 1 count of fraud. She was sentenced to 5 years in prison with a non-parole period of 3. She was 43 years old. She had 14 years of covering financial crime. She sat in the dock and looked at the jury and made the decision, in that moment, that she was going to find what Stewart Greer had done, and she was going to prove it. She did not know yet how, but she had 3 years, and she was a journalist. Diane entered the Dame Phyllis Frost Center in Ravenhall, Victoria, in April 2009. She was 43 years old. She had, in her prison property intake, 3 legal pads, 2 pens, and a copy of the relevant securities legislation. She began immediately. The first thing she needed was documents. Documents that had not been disclosed in the prosecution. Documents that the investigation had not looked at or had overlooked. Documents that, in a financial fraud case of this complexity, the trail of evidence required. She filed Freedom of Information requests to ASIC, to the Australian Securities Exchange, to 2 financial regulators whose records she believed contained relevant information. She filed these requests herself, from prison, using the legal mail system. She was patient. She knew how to wait for documents. She had been waiting for documents for 14 years. The first responses came back in August 2009. Most were heavily redacted. She filed objections to the redactions, citing specific provisions of the Freedom of Information Act. Some redactions were overturned. New documents arrived. She built a timeline. Not on a computer. She did not have access to one for the first 18 months, but in careful longhand on the legal pads, cross-referenced with index tabs she cut from the margins of documents. It was the most methodical piece of financial journalism she had ever done, conducted in a prison cell under fluorescent lights, without a colleague to check her reasoning, without access to the databases she would normally use. What she found by the middle of 2010 was a pattern she recognized. Not because she had seen it before in her own case, she hadn't, but because she had seen it before in a case she had covered in 2004. A case involving a different firm, different people, the same mechanism. Someone had been making targeted short-selling trades on companies that were about to be subjected to regulatory or journalistic scrutiny. The pattern was distinctive. The timing was specific. And the trades, she now understood, had been made using information that only 2 people had possessed at the relevant times. Her and Stewart Greer. She needed the trading records. Specifically, she needed the trading records for accounts that had not been examined in the original investigation. Accounts that might be registered in names or structures that would not immediately connect to Stewart Greer, but that, with the right analysis, would. She wrote to the Financial Services Ombudsman. She wrote to 2 academic researchers who had published work on market manipulation patterns. She wrote to a forensic accountant named Dr. James Carr, whose work she had cited in her 2007 investigation, and who she believed would understand what she was describing. Dr. Carr wrote back. Dr. James Carr was a forensic accountant at Monash University who had spent 20 years developing methods for identifying market manipulation patterns in large trading datasets. He was 54 years old. He had a reputation for being the person regulators called when they had a pattern they could not explain. He read Diane's letter carefully. It arrived in January 2011. It was 9 pages long, handwritten on legal pad paper, and it described, with the precision of someone who understood the technical landscape completely, a hypothesis about a set of trading accounts that she believed were connected to her case and to her former colleague. Dr. Carr said later that the letter was one of the most technically sophisticated analyses of a market manipulation pattern he had received from any source, let alone from a prison cell. He obtained, through his university's research, access to financial data, the trading records Diane had hypothesized. He ran his analysis. The pattern was exactly as she had described. The timing of the trades correlated precisely with the non-public information that Diane and Stewart had possessed during their investigation. The accounts were registered in structures that, with adequate forensic analysis, pointed to a set of beneficial owners that included one name repeated across multiple structures: Stewart Greer. Dr. Carr spent 4 months verifying his findings. Then he contacted ASIC directly. Then he contacted Diane's solicitor. Then he provided a complete forensic report to both. ASIC investigated. The investigation took 8 months. In October 2012, ASIC charged Stewart Greer with market manipulation, fraud, and perverting the course of justice. Stewart Greer was arrested at his home in a suburb of Melbourne on a Tuesday morning in October 2012. He had spent 3 years watching his former colleague serve the sentence he should have been serving. He had spent 3 years certain that he had covered his tracks well enough. He had not covered them well enough for Diane O'Yelleran. Diane O'Yelleran's conviction was referred to the Victorian Court of Appeal by her solicitor in November 2012, following Stewart Greer's arrest. The referral was supported by Dr. Carr's forensic report and by new evidence obtained by ASIC in the course of their investigation of Stewart that had not been available at Diane's original trial. The Court of Appeal heard the case in February 2013. The prosecution, reviewing the new evidence and ASIC's investigation, did not oppose the appeal. The conviction was quashed in February 2013. Diane had already been released on bail in November 2012, pending the appeal, having served 3 years and 7 months of her sentence. She had walked out of the Dame Phyllis Frost Center on a November afternoon with her legal pads, her cross-referenced files, and a forensic accountant's analysis that had been built on the foundation of what she had assembled from her cell. Her editor at the financial publication, who had, to his considerable credit, maintained throughout that he believed Diane was innocent, was waiting outside. He had brought her a coffee from the place near their office that she had been to 1,000 times. He handed her the coffee. He said, "The piece on Meridian Partners. Do you want to finish it?" She took the coffee. She said, "I already finished it. I just need a computer." They walked to the office together. She sat at her old desk, which had been kept for her, and she wrote the story she had been investigating since 2007. It was published 3 weeks later. It was the most read piece the publication had ever run. Stewart Greer pleaded guilty to market manipulation and perverting the course of justice in September 2013. He was sentenced to 7 years in prison. He served 4.5. Diane O'Yelleran received compensation from the Australian government for her wrongful imprisonment. She filed civil claims against Stewart Greer personally. The civil case was settled in 2014 for an undisclosed amount. The original ASIC investigation, which had pursued Diane and not Stewart, was the subject of a formal review. The review found that the investigation had been competent given the evidence presented to it, but had not adequately tested Stewart Greer's credentials and trading access as an alternative hypothesis. The review recommended procedural changes. The changes were implemented. Diane is 59 years old. She is still a financial journalist. She runs an independent investigative journalism unit that she founded in 2015, specializing in corporate governance and financial crime. She employs 6 reporters. The unit has broken 4 significant stories in 9 years, resulting in regulatory action in 3 cases. She keeps the legal pads from her prison investigation in her office. Not on display, they are in a drawer. She says she does not need to look at them. She knows what they contain. She keeps them because they are the reminder that the investigation never stopped, that the work continued regardless of the circumstances, that the commitment to finding what is true is not conditional on having the right tools or the right location or the right freedom. She was asked, in a recent interview, what she would say to a young journalist starting out. She thought for a moment. Then she said, "I would say, the story is always somewhere. Sometimes it is in a filing cabinet at a regulator. Sometimes it is in a trading record that nobody has looked at carefully. Sometimes it is in a letter sent by a prisoner who has nothing but time and legal pads and the knowledge of what she is looking for." She paused. Then she said, "The story does not care where you are when you find it. It only cares that you do not stop looking." She went back to work. She always goes back to work.